Good day, Crime Talk aficionados. We have a great show for you today. First, the prosecutors in the Bryan Kohberger matter, well, they disclosed their 404B evidence. In the Delphi homicide case, we get never-before-seen photos released to the public. A jury acquits a teen for killing his mom. A judge has to resign because of his not-so-great answers about the justice system when trying to get out of jury duty. And oh, the tangled web we weave when we try to deceive. We have a Mother of the Year contestant, This Day in Legal History, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell up there in the corner, and yes, you can check us out anytime on any of your favorite podcasting apps. Now, you also know that before we get to the docket, we got to talk about CrimeTalkSearch.com. Go to CrimeTalkSearch.com, and when you do sign up, you will be able to do as many background searches as you desire on anyone here in the United States. On anyone. You'll be able to check them out, just like we do. Check out key witnesses, key defendants in particular cases, anyone. And you're going to be able to find out their social media information, whether they have been divorced. Are they married? Do they have judgments against them? Do they have a criminal history? Do they have to put themselves on one of those public registries? You know what I'm talking about. Go to CrimeTalkSearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for Thursday, February 6th, 2025. And first on the docket, Bryan Kohberger. The state has released what they intend to introduce as 404B evidence. Now remember, we've talked about 404B evidence all the time. Remember, under 404A, it basically says that the defendant has a right to be tried on these charges and these charges alone, and we're not going to bring in propensity evidence. Let's say he's always stolen cars, and he's coincidentally charged with a motor vehicle theft case this time. You don't get to bring in all those prior motor vehicle theft cases, prove this particular incident, the new one, because all the old stuff is propensity evidence. Look, ladies and gentlemen of the jury, judge, he's a bad guy in the past. He is a bad guy today because we know past performance is indicative of future results. That's really what 404B is. So that's under 404A, keeps all of that prior criminal history out. But like everything in the law, there's an exception. And if you want to bring in something, not to establish that somebody has a propensity to commit a crime, but for a particular purpose, right? In this particular case, the state is saying we're doing it to establish identity of Mr. Kohberger. So it's not as juicy as 404B as you would necessarily expect, but the defense was given notice by the prosecution that the state, pursuant to Rules 404B2, the state of Idaho intends to present evidence of crimes, wrongs, or other acts. Specifically, in this case, it's the video of the traffic stop occurring at West Pullman Road, Farm Road in Moscow, Idaho on August 21st, 2022, involving Bryan Kohberger and Latah County Sheriff's Corporal Darren Duke. And they say they want to possibly introduce the citation that was introduced regarding the traffic stop. And this is where the prosecution is going to get around the 404A. Don't bring in other crimes or misconduct. It is a traffic stop after all. But here the state is saying they intend to introduce that for the very limited purpose of proving the defendant's identity, his vehicle, his address, and his phone number. And apparently this has been previously addressed under seal, but now they're finally letting it be known to the general public. And so therefore that is what they're bringing it in for. I mean, usually you don't want to bring in the fact that your client got a traffic stop, but they're not bringing it in to say, look, he's a bad driver, therefore he must have killed those 4 people, right? No, they're going to say, Judge, we pulled him over in the area. We got his name. We also got the car that he drove, which may become relevant at some point in the future trial, right? Of course it will be. And that's what we're bringing it in for, to establish his identity, his association with the vehicle, and that he is in the particular area. So there you go. But in other news in Idaho, guess what? A bill is advancing to grant firing squads for the death penalty. And that bill has been making its way through, and the sponsors call it the firing squad bill. And they're saying that, frankly, hey, it's more humane because it is quick and certain. And, the sponsor of the bill said, hey, I admit it. When you first hear the whole firing squad thing, you think, well, that sounds somewhat barbaric. It's like we're going to throw stones at somebody, right? But no, he's saying it's quick. It brings justice to the victims and their families, and it's more expeditious than other types of the death penalty, which is basically lethal injection. The sponsors of the bill there in Idaho say that, hey, there's going to be fewer appellate issues for the firing squad than the whole, injection stuff that they argue now is a cruel and unusual punishment, etc., because we already know that a firing squad is not cruel and unusual punishment, that it's been used before, and it is not inhumane because it is quick, right? Remember, there's case law out there from the United States Supreme Court that says you're entitled to something not cruel and unusual, but you're not entitled to a completely painless death. I believe that was the Mississippi guy that had some problems with his injections. It didn't go so well. And he convulsed and he did some really bad things. The Supreme Court said, hey, not a problem. You're entitled to an execution, just not a perfect execution. So anyway, Bryan Kohberger could join the other 9 people on death row currently in Idaho if he is convicted. Obviously, he's entitled to the presumption of innocence. So maybe this won't even be an issue. But if it were, he could be in line to get the firing squad if he's ultimately convicted. Anyway, the primary goal is to make sure that it is dignified and humane. And the way they plan to do it is not get volunteers to shoot. Normally what they do with the firing squad is they take like 6 people. One person has a bullet, or sometimes all of them did. And they all aim for like a little spot. They put like a little heart there, like aim for the heart. And apparently they intend to do this kind of via like robotic, mechanical. So they line everything up. They know where to aim. And the defendant would just then be killed via automatically. So you don't have all the other issues regarding, oh, did you kill somebody? Did you not? Are they going to be able to sleep at night? Et cetera, et cetera, et cetera, right? So that's the goal. We'll see how that advances through the Idaho legislature. Somehow I think it's going to pass. Then the question will be, will Bryan Kohberger get to do it too? Next on the docket, first time that photos have been released outside of what was shown in court has been released to the public. Let me explain. So we've talked about this. There was a motion from Richard Allen's defense team that prompted a response from the prosecution and led to the release of some crime scene photos that have never before been seen outside of court. So back in November, a jury convicted Richard Allen of the February 2017 deaths of Abby Williams and Libby German near the Monon High Bridge. Now, the Judge Francis C. Gull, sentenced Mr. Allen to 130 years in prison this past December. Well, last month, Allen's defense team filed a motion to correct errors, maintaining their client's conviction should be vacated, and the defense cited a purported confession from another man and the disputed timeline of the passing van to prove the key witness in the case, or one of the key issues in the case. Anyway, another factor brought up by Allen's attorneys was expert testimony from a defense witness who said activity logged from Libby German's iPhone 6 showed someone had inserted or removed headphones from the auxiliary jack. As we've talked about before, all of that information is kept in the phone and recorded. You turn it on, you turn it off, it goes silent. Somebody plugs something in, you hit play. It's all in the phone activity. It's amazing everything that's saved in there. Anyway, this logged activity happened between 5:44 p.m. and 10:32 p.m. on February 13th of 2017, the day the girls were killed. That testimony came from Stacey Elridge, a digital expert in forensic who took the stand for the defense. In response, a Sergeant Chris Cecil, an Indiana State Police phone expert who testified for the state, said it was possible water or dirt may have been responsible for the activity that was logged in the history of the phone. Anyway, Cecil told the court that he had performed a Google search during a court break before offering his opinion. Now, in his response to the defense motion, the prosecutor cast doubt on Eldridge's findings, saying she didn't file a report, log, or other information to support her testimony. Now, the prosecutors also noted the bulk of her expertise was in computer and network forensics, not cell phone forensics. Well, I get these cell phones are pretty much computer. Anyway, McClellan, the prosecutor, wrote that investigators didn't find any headphones at the murder scene. He also found it very unlikely that someone returned to the crime scene at 2:32 p.m. the moment the phone stopped moving, removing the phone from underneath Abby Williams' body, where the phone was later found, plugged in headphones, kept them plugged in for 5 hours, and then placed the phone back under Abby's body, all without logging any movement in the history of the phone. Anyway, the prosecutors wrote that Eldridge didn't examine the phone herself and could not determine whether the phone sustained any water damage at all. In support of his response, the prosecutor included multiple photographs as exhibits, 3 of them, the state's exhibits 9, 10, and 11. And it shows Libby German's phone, her iPhone 6, at the crime scene. And the photos were shown at trial, but the court's observers and the jury were able to see them. Only court observers and the jury were able to see them. Now, the photos appear to show the phone screens covered with droplets of moisture, and the phone sat among sticks, leaves, and what appears to be dirt. The phone was absolutely central to the Delphi case. Libby German used it to record the 43-second video showing the girls encountering the bridge guy, and activity data also showed the phone stopped moving at 2:32 p.m. on February 13th at 2017, which the state believes marked the moment that the girls were killed. Now, Cecil did see photos of the phone showing the condition in which it was found, and he based his conclusion in part on those photos, along with how long the phone had been outside and his knowledge and experience of forensic phone examination. The prosecutor said the defense could have called a witness to rebut Cecil's testimony about the impact of dirt and water. They chose not to, so you don't get to do it post-trial. McClellan also noted that none of it constituted new information that would overturn the result of Allen's trial. In fact, the information came from discovery material, and he believes it should have been brought up during the trial to challenge Cecil's testimony. As such, the prosecutor said the phone evidence and the other issues raised by the defense didn't constitute a basis for a motion to correct errors, and asked the court to reject the defense motion without a hearing, which I'm sure Judge Francis Segal, a.k.a. Special Judge Francis Segal, will do. And then we'll go up to the appeal. All right, next on the docket, a teen was acquitted for killing his mom. It's a little weird, though, because he had killed his dad just the year before. Meet Colin Griffith. We've talked about him before. He's 17 years old, and he's accused of stabbing his mother to death last September, and he was found not guilty on all counts. The judge ruled on Wednesday afternoon. This all took place down in Florida. Now, the verdict comes after more than a week of deliberations at the Polk County Courthouse in Florida, which included testimony from Griffith's family members and law enforcement who responded to the scene. Now, Griffith's grandmother, Susan Detman, testified saying that she saw her daughter, the deceased, Kathy Griffin, being violent towards the teen. Detman said that her daughter and her son had a rocky relationship with her family members, and she told jurors her daughter was very unpredictable. Although her grandson is accused of murdering her daughter, Detman said she calls her grandson 3 times a week, telling him to eat, exercise, and pray. Now, Griffith was accused of murdering his mother just a year after he shot his father to death in Oklahoma, where coincidentally claiming self-defense. In a press conference last year, the Polk County Sheriff, Grady Judd, said deputies and fire rescue crews responded to this house and found the 17-year-old who had actually called the sheriff's office saying his mother fell on a knife while they were arguing, resulting in a wound to her neck. Once deputies and crews arrived, Catherine was pronounced dead at the scene. When the sheriff's office asked Griffith what happened, he reportedly became immediately uncooperative and asked to speak with his lawyer. Anyway, needless to say, the sheriff's office noticed some inconsistencies in the young lad's story. They talked to witnesses who reported seeing the fight between Griffith and the mom, and remember seeing her being grabbed by the hair and dragging her inside the home. Witness also reportedly heard Catherine repeatedly plead with her son to let go. Anyway, the sheriff put out a statement. He was very gracious, of course. Oh, no, he wasn't. And I like this Sheriff Judd. He's a straightforward guy. But he says, hey, the jury determined that they could not convict him beyond a reasonable doubt to the exclusion of all reasonable doubt. During our investigation, detectives found witnesses that believe he also murdered his father in Oklahoma, and that investigation is ongoing. Isn't it funny when the defense always loses, we have to say, well, we respect the jury verdict. We see how the jury could find my client guilty, but we're going to appeal. Not this sheriff. And I like this Sheriff Judd, but he's like, we believe he did it. Next, the judge resigns. A now former judge in upstate New York is out of a job after he was successfully able to get out of jury duty, but it caught the attention of some, judicial people at the state bar. Richard Snyder served as a Petersburg town court justice for roughly a decade, with his final term that was supposed to end in 2025. In fact, he's still listed as one of 2 such justices on the tiny municipality's court website. And anyway, Snyder, however, recently resigned his position in part because he avoided jury duty by evading it by saying that generally all defendants are guilty. They all did something wrong. Needless to say, the New York State Commission of Judicial Conduct served a written complaint on the judge, and they had a hearing and decided to see what they were going to do. Anyway, the commission announced last month that the matter in a very terse 2-page decision and order. It says, on or about October 18th, 2023, and on July 16th, 2024, respondent made statements that undermined the independence, integrity, and impartiality of the judiciary and otherwise demonstrated his unfitness for judicial office. A joint stipulation by the parties reads, during the first instance, Snyder explained why he was unable to perform grand jury duty for a court in the applicable county. He said, I'm the town judge in Petersburg, he said. And according to the transcript provided to the court, the commissioner said, well, congratulations. This is the attorneys trying to see whether he's going to be on jury duty. Snyder later called to account for his comments by the commission, took issue with the way the court congratulated him. I just thought it's kind of funny the way she said it to me, like she was out for me already or something, The since resigned judge tried to explain to the ethics bar. Anyway, the judge says, I don't think I should be on this jury. He told the court. Snyder offered several reasons why he would be a poor fit to be a juror. None of them were particularly convincing to the commissioner. And anyway, quote, I didn't think I would be, that I should be on a jury being in the town judge, he said. That's what I told her. The commission asked why he would say a thing like that. I don't know, just that, a lot of people say, I talked to them. No, they're not going to pick you. You're a town judge and stuff like that. They don't want the town judge on the jury. Anyway, what he said was, I don't want to be on the jury because I know everybody that comes in front of me, well, they're guilty. And otherwise, they wouldn't be in front of me. Well, needless to say, the commission wasn't particularly impressed with that. And the judge tried to tap dance. But guess what? He's agreed to resign. So he doesn't get to do his final year as a judge. And as part of the stipulation, he also has to agree that he will never, ever seek to be a judge again. Anyway, that's interesting because, yes, I think judges can become jaded. I think all attorneys can become quite jaded when you see what goes on in the court system on a daily basis. But let me tell you a story today. I saw an amazing thing happen. I was in a courtroom and I went down to another courtroom because apparently there was this big proceeding. There was a significant case, a child abuse, serious bodily injury, quite serious. They were having a hearing to throw out the case because of discovery violations by the prosecutor. This trial started on Monday. What was more interesting is this same prosecutor was in another courtroom the previous week, but had to have another attorney do that case because this one was more serious and she wanted to be involved in this one. Well, guess what? The case that she got off on and she had somebody else cover it got dismissed for discovery violations. Thrown out. I think it was assault on a peace officer case. Then this one, the judge makes findings saying pattern of misconduct. The defense had asked for various x-rays and photographs and things of that nature. DA says, I don't have them. And then guess what? They show up on the prosecution witness list. Anyway, they see the jury. They try to figure out what the heck is going on. Needless to say, judge throws it out. So not all judges are jaded. Not all judges think everybody is guilty. They give them the presumption of innocence, or at least they fake it, I guess. But I think most of them believe that people are entitled to that presumption of innocence, and they want to make sure everybody gets a fair proceeding, both sides, the defendant and the prosecution. But that was That doesn't happen very often, ladies and gentlemen, but it's happening more and more these days. Remember, the Morphew case ultimately got dismissed because of discovery violations. It's a trend. So I've seen a lot of prosecutorial issues lately, ladies and gentlemen. Remember, they're humans and they want to win. They want to win. Next, another reason why you should avoid online dating. Make sure you go to crimetalksearch.com after you hear this. So a woman's date with a man in Florida went not so great after when they got into the car. He pulled out a gun and robbed her before kidnapping her. Sounds like every girl's dream date. No, I don't think so. Anyway, this all happened about 11 p.m. on January 18th in Tampa. Turns out the Hillsborough County Sheriff's Office posted a audio call of a 911 call and the body cam video of the woman explaining the details of the police. Listen to this. The frantic woman tells 911 that she needed police to come to this Motel 6. Please, 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 I need somebody here right now, she said in rather upset voice. She said, this guy, he basically kidnapped me and he put a gun to my head and he robbed everything. And I have it on my phone. And now, because I told him I was running to my room to get all my money. She begged for the police to respond. The dispatcher told her the police officer was on the way. Anyway, the woman became more panicked. She said, oh my God, I see him. Anyway, this guy told me to come hang out with him, she said. I'm not from here. We met online, right? I go to hang out with him and literally we're sitting in the car and everything's cool. We're just getting to know everybody a little bit, you know what I mean? And then literally pulls a gun out in the middle of the console and he's like, give me everything you got. He puts the gun to her head and starts taking everything out of her pockets. Anyway, the suspect took her phone, car keys, and her watch along with her hotel room key. And he allegedly told her that he knew she had money and drove her to the hotel where he ordered her to go to the room and get some more cash, where she tried to say she went up there and told him that's where her boyfriend was staying. Anyway, the deputies tracked down the victim's phone, which the thief had in his car, and the suspect then fled, crashed into another car. Then they took him into custody. He was identified as Elijah Silva El Shabazz, facing a bunch of charges, including armed kidnapping, robbery with a firearm, fleeing, eluding, and just happened to have a little bit of fentanyl on his person as well. Can't make this stuff up, ladies and gentlemen. And my guess is Mr. Shabazz may have had a criminal history that would have shown up if they'd got to crimetalksearch.com. Just saying. Next on the docket, a Mother of the Year contestant. That's right. The Florida parents arrested for allegedly leaving their toddler in a car when they went into a bar, turned into a nasty spat. And guess what? It was caught on video while they sat in the police car, arguing over who should we blame. Now, Christina Vitucci and her boyfriend, Joshua Harris, were arrested on charges of felony child neglect after their 2-year-old child was spotted in the back seat of their car about 8:15 on January 28th. Now, the police there in Edgewater, Florida, were called in regards to an anonymous call where somebody said that there was a child in the car and they were screaming. Anyway, ultimately, the police arrived. Both the mother and the boyfriend were then questioned separately before being placed in the back of the police car. And a camera picked up their little argument, the little lover spat that they had in there, where Miss Vitucci says, I literally cannot even just believe that all this happened. Honestly, the boyfriend responded back, oh, I can. I effing can't. This irate mother then answered, as Harris said, you brought her to the bar and you sat inside. I also asked you to leave. How many times? Vitucci told Harris, I told you effing leave. I told you not to come here, he responded. You didn't tell me not to come here, she said. I said, go home. Anyway, like I said, the caller called 911. I don't know if there's anything actual emergency, but there's a baby out there in the car by itself. And I just don't want to get anybody mad at me, but this is wrong. Like I said, the police arrived and, well, take a look at that video. Anyway, just as she was rescued, both Harris and Vitucci approached the officers and said that he was the owner of the vehicle, but hey, I'm not her mother. Anyway, it didn't quite go so well. Both are arrested and the child is in the care of social services. All right, next on the docket, this day in legal history. That's right, February 6, 1788, Massachusetts ratifies the United States Constitution. That's right, they became the 6th state at that time to ratify the Constitution. And it was significant, obviously, due to the size of the influence. The state's decision helped build momentum for the adoption of the Constitution across the other states, continuing to the formation of a federal government. On this date in 1933, the 20th Amendment took effect, and the 20th Amendment was known as the Lame Duck Amendment, and that was proclaimed in effect by the Secretary of State at the time, Henry Stimson. The amendment changed the dates for the start of the presidential and vice presidential and congressional terms, reducing the lame duck period between elections and the assumption of office, and went to make it a little more responsive. On this day in 1980, John Wayne Gacy goes on trial. That's right, Gacy went on trial in Cook County, Illinois for the murder of 33 young men and boys. Obviously, the trial brought national attention to the issue of serial killers and the legal proceedings associated with such cases. His convictions and subsequent execution highlighted the use of the death penalty in cases involving heinous crimes. And then, finally, our dumb criminal of the day. A Florida man dressed in a Dalmatian dog onesie bolted during a traffic stop after being handcuffed on one wrist, and he remained on the lam for an entire day before they finally caught up with him at his girlfriend's house. So how did all this take place? Well, please meet Keith Devereaux. For nearly a day after they attempted to pull him over for reckless driving on January 27th, Devereaux had allegedly been driving erratically, stopping and pulling away at high speeds while dropping off a passenger, according to the arrest affidavit. While fleeing from police, Devereaux eventually rammed his truck into a tree. He was able to pull himself from the wreckage and tried to keep running. Needless to say, he was quickly tased by the police officers. Ought to make his day. Despite being shocked, though, Mr. Devereaux, he's no quitter. He picked a fight with the trooper and began to push and argue with him before once again attempting to take off. Somehow, he successfully fled. By this point, though, his truck was wrecked. He had been tased by troopers, and he was had a handcuff around one of his wrists. And yet, he went straight to his girlfriend's home, one of the places they were more likely going to check first, friends and family. Anyway, the troopers watched him flee through the forest while they waited for backup. K-9 unit showed up, picked up Devereaux's scent. The dog took off after Devereaux and turned up at the girlfriend's house. His girlfriend was home at the time and told troopers she didn't want anyone to go inside, including Devereaux, because they had drugs inside and she didn't want to face any jail time. Unbelievable. Anyway, troopers tailed and filed the arrest warrant so police could return to the home the following day. When police arrived, they did detain Mr. Devereaux and booked him for reckless driving, fleeing, assault against a law enforcement officer, resisting with violence, and his girlfriend alluded to the night before, throwing a little possession of methamphetamines. You cannot make this stuff up, ladies and gentlemen. If you don't give permission, you don't give the reason why you don't want to give permission. Oh, I don't want you to go inside because there's drugs there. No, you say, I don't give you permission. That's it. Anyway, Mr. Devereaux and the girlfriend, dumb criminals of the day. Clearly, dumb, dumb, dumb. Thanks for watching. We'll see you next time. Remember, the Constitution matters.